Justice isn't just about the law. It's about the people who fight for it. I'm Jennifer Long, CEO of Equitas, where justice isn't a concept, it's a commitment. And this is Just Champions. This season, we're breaking down the most critical court cases shaping the fight against sexual violence, intimate partner violence, stalking, and human trafficking. Each week, we sit down with prosecutors and scholars to break down the decisions that define justice and to discuss the challenges that still remain. Because the law isn't just theory. It's the foundation of real lives, real cases, and real change. Hi, everyone. Welcome back to Just Champions. And I'm so excited to be here with you all today because I am sitting with an old friend and colleague, former Cook County State's Attorney, Anita Alvarez. And just a little bit about her in her capacity as State's Attorney of Cook County. She managed the second largest prosecutor's office in the nation. At that time, it had over 1,500 employees. One of the reasons I got to know Anita is because she started the first ever human trafficking unit focused on combating both sex and labor trafficking, which was very, very unique. And that led to the creation of the Cook County Human Trafficking Task Force, which is comprised, and at the time was also comprised of local and federal law enforcement, as well as social service providers. And it became a model for the country. And I'm also very happy that she created it because one of the attorneys who led that, Lula Ngatano, now works at Equitas. And in addition, she also created the Cook County Regional Organized Crime Task Force, the Mortgage Fraud Investigations and Prosecutions Unit. And that was a very proactive unit that was used to combat mortgage fraud. And a lot of these crimes and violence against women, even they really go hand in hand. And some of the tactics, too, that you learn when you're putting these together, some of the technologies are applicable. So really a fantastic background. Currently, Anita is the chief legal counsel at Maryville Academy. And prior to that, she was the managing director with Alvarez and Marcel Disputes and Investigations in Chicago. A lot, but you've had an amazing career, Anita. Hello.
Oh, it's so good to see you again and to be able to talk about some of my, topics that really, it was an honor to serve as state's attorney and to be able to implement so many new ideas and always with the focus on victims, right? And victims of crime and what we could do better to help them.
Your experience transcends your leadership of the office and the units that you created, your work as a prosecutor as well. And I wanted to talk to you a little bit about your experience prosecuting sex crimes and leading an office that really prioritized those crimes.
Yeah, as I mentioned earlier, it was an honor, to lead the office, but, being an assistant state's attorney, because that's where I went right out of law school. And the reason I chose that, most people don't realize my undergraduate degree was actually in social work. I have a BSW from Loyola University. So I always was kind of wired to want to help people, right? And then started taking criminal justice classes, went to law school, really got the bug to be in court and be on that criminal justice side of things. And so I always thought that it was a good way to combine that background and my thoughts about advocacy for victims as a prosecutor. And because I think many times the victim is forgotten. And we, as prosecutors, are there to help them and to seek justice. And so I think it was a good combination of being able to help, and then also the plus of being in court and trying cases, because I won't lie, I love that. Yeah. Love that aspect of it with jury trials. So it was, I believe, a good combination of my degrees.
And I think you and I had very similar experiences, I would say, growing up as sex crimes prosecutors over the time frame that we did, because we certainly saw the introduction of DNA and evidence into the prosecution of sexual assault, rape, and what that did. And how it changed the way we prosecuted these cases, and actually how some things, sadly, remain the same. So could you talk a little bit about the role of DNA in sex crimes from your perspective? What changed over your 30-year career?
Oh, I mean, so much has changed, right? It has evolved. I remember those earlier days with DNA at the very, I would say, kind of infancy of using it as evidence in court. One particular case that I had was a 5-defendant case, and it was a murder. It was a double homicide, but the female victim was raped, and this happened in the early 90s. And at that time, there was not the testing that we see today and not the evidence that can be produced today. But one of the offenders in that particular case had a stain inside of his boxer shorts that was a mixture of semen and blood. At that time, in the early 90s, the best that Crime Lab could do as far as evidence for court was to say that the blood was consistent with the victims and it was semen. And fast forward, right, to what we see today and the advancement in DNA, it's been a godsend. And so much, the evidence now that we can produce that is, uncovered through DNA is much better than what we were dealing with in the early 90s. So I've seen it evolve, and being able to put prosecutors in a better position as far as presenting stronger evidence. Because the other thing I think is jurors want to see it today, right?
Yes, there's a study that talks about the expectation of forensic evidence in rape cases specifically is higher than any other case, that there's an expectation to see this. And you and I both know, in many ways, DNA, obviously, it can be very, very important. It can confirm the identity of the perpetrator, and it can lock in certain defenses. I think you and I both remember before DNA, there was a lot of this never happened. I never saw this person. And then once DNA created a very remarkable inconsistency when you would have that statement and then the DNA results would come back, people started moving more towards consent. And in fact, even through my career as a prosecutor and after doing the expertise through Equitas and other places, we've strangely seen that consent defense come up even in stranger cases where you've got the forensic evidence and it almost seems, in circumstances that are so far-fetched, you could have a runner running through and literally dragged off the street. And still, it's interesting to me, right, that the defense will still go back to that consent defense.
Yeah, that is interesting. That's very interesting. And then sometimes I think DNA sometimes could probably create more questions than answers. And I think, the general public is so used to watching Law and Order where you get DNA results in 30 minutes. We know that's not true. But, a lot of times it'll create more questions, right? One particular case we had where there were multiple offenders and on the they were convicted, but then in the post-conviction arena, they asked for further DNA testing, and their DNA was not found on the victim. However, the victim, unfortunately, was a sex worker. And so there were 3 more male profiles that were extracted. And when we went back and redid testing, so that didn't give us any answer, did it? It kind of just unfortunately solidified the world that she was in, but it didn't help us point to who the killer was.
I think that's a thing I have always really appreciated. We've had the opportunity, besides Lou, to work with other prosecutors from your office. And I think the care and concern that we've always seen, the fact that, if an individual in the sex trade does make a report of rape, that those cases were taken as seriously by your office as they should be, but they were taken that way, that victims were respected. I think it comes back to how you started this conversation, actually, with the victim always at the center, that you were prepared to explain what it's like to be in the life and to dispel some of those misconceptions that just because a victim, either before or after their rape, has engaged in sexual activity. Some of it can be forced. I mean, you started a trafficking unit, so just I feel like telling that story and reminding the jury that what the victim's circumstances are, particularly for women in the sex trade and others in the sex trade, that it's not an appropriate way to discredit someone, that somehow the rape didn't happen or didn't matter. No, I'm kind of moved a little from DNA, but I feel like when we're talking through that, that's one of the things that really always impressed me with you and your office, that you stood up for victims, all victims. You didn't determine who was worthy and who wasn't worthy of justice.
Well, thank you. And as you know, for your experience, yes, someone who is in the sex trades can be the victim of a rape, can be the victim of a crime. And we saw it happen way too many times. And they need to be treated with the respect and as any other victim.
So just in talking about victim worthiness, one thing I think that was a really unique vantage point you got to see through the course of your career was the discovery of these untested rape kits. And in fact, I remember being in Chicago there used to be, it still may exist, nonprofit Test 400K, because there was this estimation that there were 400,000 untested rape kits, which I think is such an important story, because so often, and again, never wanting to minimize wrongful convictions or wrongful identifications. Those are horrific. As prosecutors, we want to do everything we can to avoid them. But the other story is that so many victims who might be overlooked, and in some of those cases, because of victim worthiness. Can you talk a little bit about the untested rape kits and just that story, if you will?
It's actually mind-boggling when you realize how many were just sitting there. Once obviously there's been an arrest for a sexual assault, or even if there was an arrest, a rape kit is taken, right? And those are sent to the crime lab, and they were just never seemed to be a priority for law enforcement, right? And particularly in cases where the victim was the victim of a sexual assault, reported it, no offender in custody, right? And they just kind of boxed it up and sent it, in storage. And no one thought that it was important to work those up and see whether or not you can get a profile. Many times there were serial rapists out there that were, continuing to commit crimes. So I think it was devastating to see the backlog. And I understand that the crime lab has always been overtaxed in many ways and, not having enough funding. And I get all of that. But when we're talking about something as vicious as a sexual assault, to let those kids just sit there, it was, frustrating for us to see. But it took a while, as you know, to get to the point to, get through, the powers that be to say, okay, this is a priority. We have to switch gears here, and we have to make sure that we work up these cases.
Yeah, that we test these cases. There are so many reasons. One thing, we've done a lot of work at Equitas and looking at charging and trying to look at the studies that have been done on attrition rates, those studies that look at how sexual violence cases are uniquely weeded out of the system and the reasons why. And in doing that, to learning about, I think the technical term is downstream orientation, but the real term is basically how our practices as prosecutors can influence other people in the system, and in this case, law enforcement. So when our work on the untested rape kits, one piece has been, okay, before we even get to prosecuting a cold case or a case with DNA, thinking about how our behavior, how, our approach to these cases, our willingness to charge difficult cases, our capacity to charge them because we understand what we need to legally, forensically, medically to be able to take them, how doing that makes it more likely that investigators, therefore, will investigate to include testing these cases. So that was, I feel like, one of the lessons coming out of there, I think, was how prosecutors can contribute to that or how they can make it better. The other one went back to that victim worthiness, this idea of based on a victim's lifestyle or background, was there really a rape? Were they really credible? And were those some of the reasons why they sat?
Right, exactly. Yes. changing the mindset of law enforcement. I think we had to do that in several different arenas. One would be with the rape cases and those rape kits, and getting through that this is important. They need to do it. And we also saw it in the human trafficking when we first started the unit. There was a period there where we really had to change the mindset of law enforcement. Police officers, the department was kind of like, they're they're not.
You don't
trafficked.
understand.
Exactly.
Right.
They're in this
they didn't
life
understand.
because they want to be in this life, and they're not a victim. So, those first couple of, I would say the first year of putting that unit together was working on changing the mindset of law enforcement. We changed the law in Illinois. And, I always said it was kind of backwards that we always had the ability to go up on a wire where people selling drugs, but not people selling children. And that was backwards. And once we changed the law and got that ability to do that, even then, the first wire that we did, there were officers that we had some great, don't get me wrong, we had some great cooperation and great work done. But then there were also some that thought, this isn't a real important wire,
Right. Took a long time for people to understand, to get bought in, to understand these crimes, because again, they're hidden. So once you start hearing these wires and start putting these cases together, you see the horror that these victims are under.
Exactly.
And just like the wires, I feel like the DNA also raises unique legal challenges. And I know you talked about some of them earlier on, but what are some of the other legal challenges around DNA that you saw as a sex crimes prosecutor or in leading your office that you had to learn how to overcome?
Just the presentation of the evidence, right? And we know there's a new case that just came down last summer that somehow there's a question whether what the ramifications of that's going to be for prosecutors presenting the DNA evidence. I mean, we talked a little about, we've come a long way and results are quicker now and more exact. That's all tremendous. And it could lead to implicating someone, or it could lead to an exoneration. That's all wonderful. But in order to get that evidence into your case, there are rules that I think somehow maybe make it seems like it's becoming more difficult for prosecutors to present that evidence and present it correctly so that they're not looking at, like what we saw in Williams, a confrontation clause issue, or what we saw recently in the Smith case.
I really appreciate, we always think of DNA forensic evidence as very technical, the science around it, how do we interpret it, the collection of it, but also important is the practical aspects of how do you introduce this? How do we take scientific, these advances, we take them for granted, but how do you explain it to a jury and how do you admit it? And Williams and Smith, very procedural cases, but we might as well jump right into them. Williams v. Illinois. And I do like to start, and that's why I'm especially grateful that it's you, because this was your case. Not yours specifically, although it might have been out of Cook County. But I always want to talk about the victims because, Williams v. Illinois and Smith v. Arizona up to the Supreme Court. And I think we have these cases in books and forget that there are people. And in the Williams case, there was a rape victim in that case. And I wondered if you could just tell the story of that case before we get into the law and what happened and the evolution of the case law and analysis.
Oh, absolutely. And I did not try. It's Sandy Williams is the offender. And I did argue the case before the United States Supreme Court, which was, talk about stressful.
Anita, I have no idea.
Yes.
See, this is, how do I find these things out? I had no idea.
I argued it. I was, talk about stress. It was quite stressful. But an honor, again, to be able to argue a case. I mean, as lawyers, it's every lawyer's, I think, dream. And it's a one in a lifetime opportunity to argue before the United States Supreme Court. So I did. I got to argue the case. A lot of preparation, let me tell you. But as far as at the trial level, I did not try the case. Actually, I do know one of the prosecutors who tried the case. She's a judge now here in Cook County. But Sandy Williams, just going back to the facts of that case, the victim in our case was, as we would say, stranger danger, right? She was coming home from work, and he grabbed her literally off the street and sexually assaulted her. She did not know him, and he got away. She ran home, told her mother, and they immediately made a police report. She was taken to the hospital, and a rape kit was done. That was in February of 2000. That rape kit made it to the Illinois State Police Crime Lab, who is the lab that works everything up for Cook County prosecutors. The lab has always been overwhelmed, and they routinely would outsource cases and outsource evidence. And they did in this case. So her vaginal swab was sent to the crime lab in Cellmark in out east. I think that's Virginia. I'm not sure, but it's out east. So it was sent to Cellmark and basically to work up to see if a male profile was present. Now, the offender, Sandy Williams, was not arrested. He was not known. She didn't identify him at that time. She didn't know him. So Cellmark does its testing, and I think we know those crime labs. There might be, 5, 6, 7, 8 people who take the sample. Maybe this person takes it, puts it in the initial, liquid, and then it's taken out and put in another, that sort of thing. It's almost like an assembly line kind of thing. Cellmark extracts a male profile. And again, still unknown, and sends it back to Illinois State Police, a male profile. So it's at that point, unknown male profile was extracted from that sample. Sandy Williams then, in April of the same year of 2000, gets arrested for yet another sexual assault. And this time he's arrested. And this time his DNA is put into CODIS, put into the database. The lab at Illinois State Police.
Hey folks, Jennifer here. I want to jump in with a quick definition for this conversation. The FBI launched CODIS, which stands for the Combined DNA Index System, in 1998 to aid investigations. And this system blends forensic science and computer technology into a tool for linking violent crimes. CODIS enables federal, state, and local forensic labs to exchange and compare DNA profiles electronically. And this links serial violent crimes to each other and to known offenders. So the searchable indexes in CODIS can be divided into 3 categories. Offender, which includes DNA profiles from individuals convicted of crimes. Arrestee, based on state law, which means DNA profiles can be taken from individuals at the time of arrest. And forensic foreign DNA profiles. These are from crime scenes, and they're not matched to a victim, suspect, or elimination samples. Each state has a local state database system. There are also local database index systems, and each have different criteria for accepting uploaded forensic material. Okay, back to Anita.
She basically, as they routinely do, run that profile to see if it pops up in any other, unknown offender cases. And sure enough, there was a hit. So at that point, the Illinois State Police Crime Lab, the analyst, made the match, right? So based on what she had, a known sample from Sandy Williams, now tested it and examined it and compared it to that unknown male profile from Cellmark and makes the match. So he is then, arrested and charged. And the victim in that case also picked him out of a lineup. So she did positively identify him. So he's charged on this case. And when it went to trial, it was not a jury trial. It was a bench trial. So just in front of the judge, and the prosecutors presented that evidence and did not call anybody from Cellmark. Okay, they called the Illinois State Police analyst, and she testified or she made the match, right? She made the match. And, she got all of that in. The Cellmark report was not admitted into evidence at trial. And she testified there were objections. There was a confrontation clause exception. Objection at the trial level as well. The judge overruled it, and he was found guilty. It was the case went up on appeal, and it was affirmed. And then, the petitioner at this point, Sandy Williams, kept appealing and ended up, filing a PLA, and it was taken up by the United States Supreme Court. So the issue, as you know, was confrontation clause, and their argument was that they should have had the opportunity. Williams should have had the opportunity to confront Cellmark, I guess, and everybody who might have touched that sample at Cellmark. The ruling, as you know, was I won, albeit 5-4, and with a concurring opinion by Justice Thomas that kind of laid out while he was concurring, he felt that the Cellmark report was not testimonial. And I think we'll probably continue to talk about this as we go along.
In episode 13, we discussed the Supreme Court case Crawford v. Washington and its progeny, which were critical in defining the way the confrontation clause applied to certain out-of-court statements that the court termed testimonial. Specifically, the court held that an absent witness's testimonial out-of-court statement is inadmissible unless the witness is unavailable and there was a prior opportunity for the defense to cross-examine that witness. Now, the court didn't lay out the definition of testimonial, famously writing that it would leave that task for another day. It did, however, provide examples of both testimonial and non-testimonial statements. In 2009, the Supreme Court decided Melendez-Diaz v. Massachusetts, which held that an analyst's written findings, specifically a certificate analysis, were not admissible without the testimony of the analyst. And in 2011, the Supreme Court reasserted that decision when it rejected the prosecutor's attempt to introduce a lab report through a surrogate analyst testimony in the case Bullcoming versus New Mexico.
But the new case that was just ruled on last, I think, June or July, Smith, kind of changes things, and I think kind of puts prosecutors more in a position where I think we're going to have to really figure out how, going forward, how that Smith case is going to affect, right, prosecutions like Sandy Williams and, going forward and presenting the DNA evidence.
Yes, exactly. Because the court thought that the fact that Williams v. Illinois was a bench trial was important because the holding relied in part on the finding that the lab report in question, which was the profile of the defendant's DNA that was developed at Cellmark, which was the lab from which there was no analyst to testify at trial. It was just the report. The court thought that was important because a judge is seen as, being able to follow the law, to be trusted to only consider evidence for its allowable purpose that it's being offered for, basically not to be prejudiced by it. So for this reason, the Supreme Court in its Williams decision determined that the trial court judge understood that the testimony wasn't admissible to, quote unquote, prove the truth of the matter asserted, that the matching DNA profile was found in semen from the vaginal swabs taken from the victim. And I'll say the Supreme Court found it unlikely that the judge took the testimony as providing chain of custody evidence. And in reaching the conclusion, the Supreme Court pointed to the fact that the trial record didn't support an understanding that the trial judge thought it was providing chain of custody evidence. In fact, the court decision said the admissible evidence left little room for an argument that the Cellmark sample came from any source but the victim's swabs, since the profile, matched the very man she identified in a lineup and at trial as her attacker. And just one more thing. So the decision in Williams is known as a plurality because 4 of the 5 justices who decided in favor of the prosecution made their holding based on a determination that the lab report that the analyst from the Illinois State Lab was testifying about wasn't being offered for the truth of the matter asserted. Instead, they saw it as part of the materials that the analyst could base his or her expert testimony on. And the fifth justice agreed with the outcome, but for a totally different reason. They wrote that the report wasn't testimonial because the lab report wasn't certified. So some legal analysts thought that the Williams decision created more questions than it answered. And in 2024, the court decided Smith v. Arizona. And this was a drug case where the analyst that performed the report did not testify at trial. Instead, the prosecutor called a different analyst who reviewed the report, the analyst's notes, and then gave an independent opinion. And the Supreme Court ruled that the notes and the reports were offered for the truth of the matter asserted. There was no record developed, though, on whether they were testimonial in nature. So the Supreme Court returned the case, they remanded it or returned it to the lower courts to decide that question. And the Supreme Court, in deciding that the statement was offered for its truth, they reasoned that the truth of the absent analyst's report is what made it useful to the prosecution. I mean, the credibility of the testifying analyst could only be determined in reliance on the absent analyst's reports. So this holding abrogates, basically annulled the holding in Williams. And the one thing that's really, I think, always interesting about the Supreme Court, and they've done it many times in these, I'll say these confrontation clause cases. I mean, Williams v. Illinois and Smith v. Arizona, and there were a few before, deal with physical evidence versus testimony, but Crawford, Davis, Hammond, and then many times we'll hear the court really struggle or take time to analyze the practical implications. And in these cases, they did bring up the practical barriers to bringing different analysts in. So they did acknowledge it. And I think in some ways they offer through the opinion or through our own experience, offer some strategies for how we can work within the new analysis of the confrontation clause and make sure that we can still prosecute and still get justice. And I know one of the things, and I think this was even back in Williams, they talked about this notice and demand as a strategy, basically providing one strategy. If you want, you provide notice to the defense counsel of what you're going to do. This is assuming, of course, that you still have analysts that you can get, but we're going to rely on this opinion. And if you demand that we bring the analysts, then you have to let us know so we have time to get them and to bring them all in. And so that's, one of the strategies. The other, if you are in a situation with cold cases and serial cases, other strategies that I've heard some of our staff and other people talk about are these strategies where you might determine if there's enough sample left to be retested, and that might make it available. Or they even talked about talking to the analyst if it's a case that's not old. I mean, again, when you're talking about cases, you could be talking about a case that's, a few months old to decades old, where this material has been there. And thankfully, with the new technologies you talked about, we're able to test smaller and smaller amounts. But when you're talking about a more recent case, another strategy I've heard is to talk with the analyst who maybe wasn't the testing analyst, but who observed or took part in some of the testing. Mm-hmm. Are there other strategies that you had heard of, too, in terms of dealing with, if we're in a situation where we can no longer have an expert rely on this report, basically, when they're giving their, to form an expert opinion about the forensic evidence that they're being questioned about? Do you have other strategies?
Well, I think I was thinking about the retesting, because that is something that we talked about. And that is something that I think comes up. Is it possible to retest? Can you retest? And that way you'll have a whole new analyst and the ability to get all of that evidence in through one person. I think the barriers for prosecutors, I like what you said, pretrial. Okay, I think there's going to be, unfortunately, more pretrial work to be done here, right? To put the defense on notice, maybe get a stipulation. Maybe there's something that you can get a stipulation that'll help you with just not just chain of custody, but, before you start calling every person in. I think in Sandy Williams, when I spoke to the trial ASA, she said, "Oh my God, Anita, we would have had to fly in 10 people, from Cellmark, just, and put 10 people on the stand." I think logistically, that's
a barrier.
Right.
You can't overcome that.
Right. You can't. And so, and that's what I think the court has to realize when they're making these decisions. There are practical, there's practices that this is going to affect. Right. So I think pretrial getting maybe a stipulation, maybe retesting if that's available. The other thing, someone in a supervisory role, then that way from the same lab. So that way you'll have that testimony, independent, but really just, I guess, stamping what the analyst did. It really does have practical implications for prosecutors going forward. It really does.
Is there another reason for the facts and circumstances that have been documented that isn't for the prosecution of a particular individual that might also help with the analysis of this type of forensic testimony and maybe make something more admissible?
Yeah, absolutely. I think, in articles that I've read, if something is done for purposes of maybe a public policy, an issue that's not necessarily creating evidence for a prosecution, then at least from the rulings from the court, it seems like that would be admissible and that would be helpful in getting your evidence in. I think the concern is, and we saw it in, even those cases that were, I remember, reading and just digesting, for the argument, and that was Bull Cumming, and those cases were, we're talking about affidavits, we're talking about certificates, and I think those are readily distinguishable from, a rape, the DNA evidence that we had in Williams, and, a match, a DNA match off of a rape kit. So again, I think, we have to not forget about the victims here.
If we maybe frame the question to our analyst who's on our testifying expert, right, who may not have analyzed the information, but framing it as a hypothetical, would that then take away this legal challenge that the underlying lab report was being offered for the truth of the matter asserted?
I think it would, and I think based on that ruling in Smith, they're kind of telling us to do that. And even though we've kind of gotten away from that, right? Years past, the hypos were used more frequently. Now I think they're telling us to kind of go back to it. But if that's what needs to be done in order to properly get the evidence in, then I think that's something that prosecutors need to be doing.
And now I have a series of 3 kind of quick questions that I like to ask everyone because I think it gives so much insight, perspective into you amazing people.
Okay. Well, thank you.
You ready?
Thanks for having me.
Of course. Okay. So here's the first question. What is the hardest lesson that you ever learned in the courtroom?
You're not always going to be successful, right? You're not always going to win. And it's not about winning. It's about seeking justice. And there are times where, getting a not guilty, and I felt that I let the victims down, let the victim's family down. So you always want to be successful, not to get a number. That's not what I'm saying, but be successful in obtaining justice for a victim or their family. And when you don't do that, it hurts sometimes, So I think, but, you can't think you're going to go in with every case and be successful. We've all had those cases where we thought we had overwhelming evidence, and the jury, comes back the other way. So, but you have to just keep plugging along.
Yeah, you do. What would you tell young Anita Alvarez about this work?
Oh.
young you?
I would probably tell young Anita Alvarez to do it again. I think serving as an assistant state's attorney and then as the elected was really an honor. And I always felt every day that I was doing my best for victims of crime and putting my name on the record, on behalf of the people of the state of Illinois. And I think it's a good way to be a lawyer. I mean, every lawyer no matter where you're at in your field, whatever your practice is, you're helping, right? But I think the satisfaction you get being a prosecutor is so much better than a big law firm.
I agree.
The money might be better, but
Yeah. And all kinds of law are interesting to all different people.
Sure.
But for me, I totally agree with you. Prosecution was the best. And so this might be obvious, but what keeps you coming back to the work, even when it's tough, even when you feel like you've let a victim down?
Well, I think, again, that unfortunately, there's always victims and there's always people to help and there's always people for you to speak up for. So maybe something doesn't go your way, that there's other people that you can help and other people that are relying on you. And so I think that's what really always got me going in the morning. And, and again, the job I have now is still mission-based because, it's a social service agency. So I'm helping people in a different way. But I do, I do miss my prosecutor days.
Oh, Anita, thank you so much. Thank you for your leadership. Thank you for your work on behalf of victims, continuing even through to this day, your service to the community. And thank you so much for being here with us today.
Oh, thanks for having me. This has been fun. I was a little worried.
Very fun. Oh, it's great.
Thank you.
Thank you. This podcast discusses the violent crimes of sexual violence, domestic violence, stalking, and human trafficking. If you need support, please check the show notes for links to hotlines and agencies that can help. For more information about Equitas, please go to equitasresource.org. That's AEQUITAS resource.org, or follow us at Equitas_resource on Instagram. This series is executive produced by Jennifer Long, Equitas, and Robin Hopkins. This series is sound designed and edited by Dan Kroll. This season of Just Champions is funded by a generous grant from the U.S. Department of Justice Office on Violence Against Women, supporting efforts to improve justice in cases of sexual violence, intimate partner violence, stalking, and human trafficking. The opinions, findings, conclusions, and recommendations expressed in this podcast do not necessarily reflect the views of the Department of Justice Office on Violence Against Women.